The world makes way for the man who knows where he is going. Good evening and welcome. This is Face the Nation. Our topic of discussion today is the rule of law. Joining us tonight on the show are Krishmal Varanasuri, attorney at law, Srinath Pereira, President's Counsel, as well as attorney at law Nishan Premati Ratna, sector specialist for commercial law reforms, Ministry of Justice. Let's start off tonight's show with Srinath Pereira, President's Counsel. Mr. Pereira, interestingly, we're talking about the rule of law in Sri Lanka at present. Do you think this government has done justice to that?
Certainly not.
Why is that?
Because for rule of law to operate, we have to ensure that there is an independent judiciary and an independent public service. Now, with the bringing in of the 20th Amendment, I find that the entire power in relation to the appointment of persons to these so-called independent commissions, to the Supreme Court, to the Court of Appeal and the High Court, are brought in under the hand of a single politician, namely His Excellency the President. We all know that in the 1978 Constitution, J.R. Jayawardena took the same sort of position where, even though when you look at the 78 Constitution, one sees that there is a so-called separation of powers, if you really critically analyze the provisions contained in the 1978 Constitution, you will find at the end of the day, one single individual, meaning the President, was controlling the entire show. So, superficially there was something called separation of powers, but intrinsically there wasn't. Now, with the, fortunately for us, during Mrs. Chandrika Bandaranaike's time, the 17th Amendment was brought in, by which to some extent the ground was created whereby the public service and the judiciary could be given an opportunity to act with independence. That is with the creation of the Constitutional Council, where instead of one person deciding who these individuals should be, who should be appointed to these independent commissions and the higher positions in the judiciary, it was brought under the control of the so-called Constitutional Council, where unless they approved the names that were sent by the President, such persons could not be appointed. So to some extent, there was a leveling process brought in whereby the public service as well as the judiciary or the judges could act with independence. Then that was reversed by the 18th Amendment, where we went back to the original J.R. Jayawardena era. 19th Amendment brought back again changes which were not 100% perfect, but very much for the benefit of the people, in that it created a situation where these commissions and the judiciary, the public service, were given an opportunity to act independently. And now with the 20th Amendment, we have gone back on that, so that we are in the J.R. Jayawardena era. Give me just 1 minute to give you say one thing. There was also an eyewash brought in by the 18th and the 20th Amendments, whereby in place of the Constitutional Council, they brought in something called the Parliamentary Council, which consisted of 5 individuals, namely the Prime Minister, an MP nominated by him, the Speaker, the Opposition Leader, and a Member of Parliament nominated by the Opposition Leader. On the face of it, 3 are on the right hand side, that is on the government side, 2 are against it. Fine, that's all right. But if you look at the provision relating to the Parliamentary Council, you will find the Parliamentary Council is a mere eyewash, in the sense, if the President decides to appoint somebody to any one of these independent commissions and or to the higher positions in the judiciary, right, what the 20th Amendment provision says is, he can call for observations or the so-called parliamentary commission can send observations and the president is under no legal duty to abide by the observations sent in by the parliamentary council. So that, if I may use the expression, he can take the so-called recommendations which are sent, the observations sent by the parliamentary council with the left hand, hand it over to the right hand and put it into the waste paper basket and say, to hell with it, I appoint the person whom I want. So therefore, for us to have an independent judiciary and independent public service, we have to create the groundwork whereby those individuals can act with independence. But and as it is, I find, when you know your master, His Excellency's voice is a final thing in my career, what do you expect it to have?
Mr. Pereira, however, when this government was appointed a few years ago, President Gotabaya Rajapaksa, the people in Sri Lanka wanted a strict governance structure in the country. They wanted reforms to the 19th Amendment of the Constitution, especially after the 21st April attacks we witnessed a few years ago.
So are you trying to say that the 20th Amendment has brought in such a governance? No. Instead, in place of that, we have gone away from that concept. In the sense, as I see it, the 20th Amendment has created a situation whereby the opposite will be the final effect, in the sense, one individual will control the entire thing as long as he is there, and when he is gone, make no mistake, let's say this government is changed and new government comes into power, they will not be able to change these provisions unless they get a 2/3 majority, one. Secondly, the new government that comes into power may well, even if they have a 2/3 majority, may well think, fine, why should we now change this? There is total power given to the president on a platter, why should we change it and disturb the whole system? So therefore, I don't think I don't know what the people wanted, but whatever they wanted, they have not achieved it. They have in fact achieved the total reverse of what they probably wanted to achieve.
Thank you very much, Mr. Srinath Pereira, President's Council.
I'm not being personal, but these are my very sincere views that I'm
Thank you very much, Mr. Pereira. We now move our attention to Mr. Krishmal Varanasuriya, attorney at law. Mr. Varanasuriya, a few years ago, when Shirani Bandaranaike was impeached as Chief Justice of the country through the Parliament, you were one of the staunch vocalists, or came out in strong protest against the removal. However, today Minister of Justice, Minister Ali Sabri, makes a statement. He says that removing Mohan Peris as Chief Justice was unconstitutional and that he would speak to Prime Minister Mahinda Rajapaksa to rectify this mistake. What does this statement really mean? Now, what would happen to Shirani Bandaranaike, who was appointed subsequent to the 8th April elections, where President Maithripala Sirisena took over office? What's going to happen to that appointment now?
Yeah.
Reappointment. Yes.
Yeah. Firstly, thank you, Shamir, for you and your production team for inviting us once again to your August Assembly. Good to see all of you after a while. Almost a year, I think, that I've been here. Thank you. You've bowled a Yorker to start off. As to what my learned friend, who I practiced with previously, I don't know him as Justice Minister, but I know him as a learned friend with whom we've had many a struggle. As to what he meant, I'm sure he will explain in due course. As to what he meant, we really don't know. But as you said, Shamir, that statement is very concise. As to him speaking to the Prime Minister and trying to rectify it. But may I just say this, you're right. At that time, we campaigned against what we thought was an unjust move against the apex court. It was not to defend a person. All the lawyers that got behind us and came out on the roads with us and went into court and challenged it, and we spoke to media like yours, who very kindly took our voice to the people, was because we wanted to show that the separation of powers that's in our constitution must be enforced. You can't allow the executive and the legislative arms of government to encroach upon judicial power of the people, and that was what we were defending. But there, what you say may be because between the 43rd and 44th, their lordships, the Chief Justices of this Republic, there is a lacuna. No? There was a 43rd who was impeached and we fought it. And the 44th was put in office, that's his Lordship Justice Sri Lanka. Now between that, his Lordship Justice Mohan Piris was also Chief Justice. Now, but also let's not forget her Ladyship Shirani Bandaranaike, the then Chief Justice, didn't actually come back to office. I remember this very specifically. During those days, we were also wondering after the Yahapalana government came in and they wanted to rectify what they thought was a previous anomaly, her Ladyship didn't actually come and assume office on the bench. She came to work, she came to the court, and if I remember correctly, the previous removal of office was rectified so that she could get a terminal benefits and pension rights. I am not too aware of the details, but she never enthroned on the bench, that's what I am saying. So she never sat as a judge. So it was his Lordship Justice Sri Pavan that continued. But there is a question between 43 and 44, we can't have 43 and a half, no, or a 44 and quarter. So there has to be some finality, I suppose, from the point of view of someone looking at this as to what happened to the appointment of his Lordship Justice Piris. Now, as to whether it's unconstitutional or not, that's not something unfortunately the Prime Minister can decide. So however much my learned friend may want to speak to the Honourable Prime Minister, they can't solve it on their own. It will have to go through a process of legislative government.
Yeah, but Krishmal, respective governments, even the Yahapalana government in 2015, had Shirani Bandaranaike coming into power again as the Chief Justice.
No, she didn't, that's what I said, she didn't come.
No, but
she didn't sit.
She didn't sit, but she came into the courts and then resigned, and then we had the new Chief Justice taking over.
Swearing in.
The swearing in. But the question mark is...
If you remember, it was the acting Chief Justice who was then sworn in. Justice Sri Pavan, who administered the oath of office to the President.
Absolutely.
Yes.
So the question is, if respective governments are going to do this, whenever they come into power, they appoint someone they wish and based on their whim and fancy. Where is the justice system in the country? Where is the rule of law in the country? What is the Supreme Court doing about all this?
What can the Supreme Court do, Shamir? We must remember that we are governed by a republican concept, which is the will of the people. So now we must assume that the 69 lakhs wanted this. You follow, we can't have a dictatorial government, no. Supreme Court Chief Justice suddenly can't get up and say, okay, out, no, you can't do this, President. You see, the people bring governments to power. You better understand the concept. That's why I actually came ready to discuss your port city, and I was going to touch on this. We must approach this question, Shamir, your very valid point, from a republican concept. Republican concept is sovereign power lies with whom? The people in our country. Unlike the England where it lies with the Queen, Queen can make dictates. I put so and so, I remove so and so. Or say some socialist states where the sovereign power lies in the state. People, no doubt, but in the state. And people act on behalf of the state, like a Politburo or a higher council or whatever. Now, Sri Lanka constitution says sovereignty lies in the people. Sovereignty lies in the people, it is inalienable, it lies in you. Now, that is why you have, with an overwhelming majority, as my learned friend Mr. Pereira said, elected a government giving them a 2/3 majority to do whatever they wish. Now, the question is, now we must assume therefore that this is what the people want. We must assume that this is what you and I must want. I mean, that's what we have expressed. No? That's what now the people's will that was expressed.
But 6.9 million voters is not a reflection of the 21 million people in Sri Lanka.
So that's why I say, Shamir, unfortunately, I think now I am part of a minority. Not a racial or ethnic minority. But I believe there is an intellectual minority in this country. And those are thinkers who think that policy-based politics. Now, I have seen the very astute politicians who live on politics, professional politicians as I refer to them all, who live on politics. They have brought that absolute sovereign power I spoke of to the level of a badumalla or a grocery bag. So sovereignty now lies in a grocery bag. So if you have millions to give as many grocery bags as possible to all these vattars, the vattars that go to election, then you can buy sovereignty. But people like us who think and vote, are a minority. So now the question for us is, are we going to be subject to the majoritarian politics where they decide, you appoint, you disappoint, you remove, you put, or maybe find some island for us to go and live somewhere, or I don't know. I'm with you on that question.
I'll come back to you, Mr. Vera, because on the first round I don't want anyone interrupting, but in the second round certainly you can interrupt Mr. Varasuri and express your views as well. So very quickly, Krishmal, before I move to Nishan, the recent wrestling move that was seen on the road by a police officer against a lorry driver, and right after right, so right after this particular incident, we saw DIG Ajit Rohana saying that people could have a self-defense system. They can always retaliate or fight back if their life is threatened. So how can someone judge that? Or what is the benchmark? And how can someone senior DIG Ajit Rohana make such a statement?
I didn't actually see this statement, but I heard about it. Ajit is right. Once again, a lawyer. The law provides the right of self-defense to all of us. You and I, if we see someone being murdered and if we feel that we have enough prowess, physical prowess, like the WWW that we saw, that policeman jumping up and down like a wrestling ring, then we can overpower him. But the repercussions of that, you see, if you and I, now say if you and I were on the road when that happened, and we went and tried to assault that police officer, the next charge is going to be for us, against us, for standing in the way of justice. Yes, there is a concept in the law that if we see a crime being committed and if there is no one to arrest it, all of us have the right of self-defense that extends to, say, if Mr. Perera is in trouble, I can jump in, or Nishan and I can jump in and save him. However, whether in this situation that applies, surely no one watching, Shamir, I don't know whether you have the time for this. What happened was police force, which was supposed to be a peaceful force, which was supposed to go up, like in other countries, go up the tree and get the cat from the tree that had climbed, or help the old lady to cross the road. After the war, the police were given AK-47 and M16s, no. So the police thought they were army. And then what happened? The police started firing on people. And so this is a big question that we have to. So we need to go back to the basics and tell the policeman, hello, you are a peaceful force. You are not supposed to wrestle with people on the road.
Right. Thank you very much, Krishma Varasuri, attorney at law. We now move our attention to attorney at law Nishan Premathiratna, sector specialist for commercial law reforms, Ministry of Justice. Nishan, my first question to you is development versus law reforms. What is more important, law reforms or development?
Thank you very much, Jamir and TV1 for this opportunity. At the very outset, I'm privileged to be with this esteemed panel. My scope of discussion today was to be on the proposed bill in respect to the port city. But addressing your question, I believe both need to go hand in hand. A developed system needs to have an effective legal system. If you do not have an effective legal system, the whole notion of development is merely a fallacy. Now, why do I say this? If you look at where Sri Lanka is ranked in the World Bank Doing Business Index at the moment, we take over 1,300 days to enforce a contract. So we are ranked around 173 in the Doing Business Index. So that means we are really low in the overall global scale in respect of overall dispute resolution. So this is an alarming fact which needs to be addressed. Now, when a development project offshoots ground and you have investors who want to come and invest in this country, and if their investment gets stuck in a dispute with a local national or with any other party, and it takes 3 to 4 to 5 years for that to be resolved, then ultimately it will be development which would be curtailed, because investor confidence is something which would not transpire if an investor cannot take out its infused capital in an instance of a dispute. So development and the rule of the legal system or the enforceability of in respect of a dispute is a matter which needs to go hand in hand.
So, Nishan, this one-stop shop concept was initially brought forward with respective governments on the BOI, and we saw a lot of corruption taking place as a result of that, because they were completely going through red tape, and as a result of that there was many issues that cropped up, and there was a lot of corruption was rampant. Now we see the Colombo Port City Economic Commission bill also being discussed right now broadly as a white paper. So what is happening here? What are your thoughts on this bill now? We've had the experience as a nation going through the rut as far as corruption is concerned, and now this bill to add to that. Do we need it?
Well, the bill should not be looked at in a microscopic perspective, I believe. If you look at it from 2014 and then thereafter the subsequent government and the present government, they all have had one voice in respect of the requirement of the port city. How it ought to be regulated is or was or is the million-dollar question. How is it going to be done? Are we going to model ourselves in respect to the Dubai model, or are we going to look at Singapore, or are we going to have our own homegrown model? So the one-stop shop concept is very important and pivotal, because for an investor, when an investor has to invest in a certain project and needs to firstly incorporate a company, so that means dealing with the registrar of companies. Then if the investor needs to get certain other approvals, building permits, the investor has to deal with those respective authorities. Now, for example, Shamir, I am before the municipality trying to build my own house in Colombo, where my plan is pending for about 6 months. So now, if that is the plight which is going to be to an investor, and where he has to deal with those separate entities independently, the whole process of commencing business will take a long period of time.
Yeah, so
my notion is you need the one-stop shop. Yes, there has been issues in respect of the BOI concept. There is no stop, there is no one, there is no shop also. So there is nothing to be found at the moment.
Yeah, so Nishan, very quickly,
yes,
before I open the floor for questions from our journalists, we have Faraz, Sonali, as well as Nadim. Very quickly, you are very modest in picking out 2 successful countries when it comes to economic zones, that is Dubai and Singapore. The countries that you did not mention is probably Seychelles, Gibraltar, Switzerland, and countries that black money is being brought into those nations and being thrown out as white money after that. So the Colombo Port City will also be a hub like that in the future, isn't it?
Well, I do not agree with that position, Shamil, simply for the reason that all the laws which are found and governed or enforced within the territory of Sri Lanka will be also in effect in the port city. So all the criminal sanctions, the Money Laundering Act, all those offences can be punished, and the Act has provided, or the bill has provided, that those can be punished by the magistrate or in an appropriate forum.
Sorry to interrupt you, Nishan, there are some exemptions.
Yeah, there are exemptions in Schedule 2, but not the criminal provisions. You can't see criminal provisions in Schedule 2 and Schedule 1. So I am not here taking a voice or a mandate of a government.
No.
I am here giving my independent view on a very cursory assessment of the bill.
Right.
So if one, there was skepticism that when you look at the port city, we are creating a separate territory which is seemingly not governed by, it can be governed by alien laws and it won't be part of Sri Lanka. My thinking by looking at the bill actually changed. I was happy with the provisions. There are issues. I agreed with my learned friend. There might be issues on the appointment of the commission and the absolute discretion vested with the president. Now those matters might have to be regulated, whether we and the nationality of commission members, they are not stipulated. They are not stated. So whether we can get all
Right.
7 members to be foreigners. So all those are matters, but this is a work in progress. So we will have to look at it. It's still in bill stage. It can go to, it can be challenged in the Supreme Court, and we can fine tune.
Thank you very much, Nishan. We of course will grill you further on that, on your thoughts and your comments. However, I want to open the floor for questions from our journalists. On to my immediate right is attorney at law Sonali Wanagabaduge. Immediate left is Nadim Majid, and after some time we have Faraz Shaukat Ali on the show as well. So let's start off the show with Faraz.
Thank you, Shamir. I think we'll start off with Mr. Krishmal, shall we? Krishmal, I talk about the port city. I noticed that the committee or the commission that will run the port city will be appointed by the president. To me, that indicates an almost appalling lack of democracy, because we are not sure as to what kind of powers that commission will have. The chief Mandarin, if you like, will he or she have the powers to grant tax concessions and whatever? And in all of this, it appears that our parliament is nowhere to be seen. So I'd like you to comment on that aspect.
Yeah, you're spot on, Shamir. Sorry, Faraz. Sorry, we haven't met for a while. But no offense meant to either. Faraz, those are some of the concerns I had as well. That's why I say we must look at it from the conceptual point of view. Now, for instance, is this, I go back to my earlier question, is this concept what the people want? Because the very point that you said and several others I'll quickly go to now. See, when, for example, when Malaysia wanted, Malaysia being traditionally an Islamic nation and very strict laws, when they wanted to make room for, party time and for people to go gambling and the girls and the music and the whiskey and all that, they asked a good Chinese gentleman, gave him Genting Highlands and said, you go and put up all your casinos there and you have your party there. So you're in Malaysia, but everything can happen there, and we'll give you a lot of, freedom to do that. Now, is that what we want to do? Is the question, because to me, this is Genting. But if you look at some of the allowances, the point that you said about His Excellency the President appointed the commission, not just that, no, Farah, you said our parliament has become silent, correct. You see, even audit has been given to the President. It says, final audit report shall be submitted to the President. Now, this is taking away a fundamental constitutional principle that we had, which is that all fiscal policy of this country up to now has been vested in terms of the constitution in no other organ but the Parliament. Why? The public purse is controlled by the people's representatives. With the President and his ministers can't spend that money, the judiciary can't spend that money, only the Parliament. Why Parliament? It's expected that the people's representatives, because all of us can't go to Parliament, direct democracy became representative democracy from Athens and Sparta those days. So we send representatives to control our purse. Now here, in the Colombo Port City Bill, the audit report is given to the President. President is the executive. Now that to me is moving away from the concept of our constitution. Now, as Nishan said, hopefully some erstwhile gentlemen will challenge these provisions in the Supreme Court when the bill is placed in the order paper of Parliament, and we'll get a chance to talk about this. But I'm just giving one example of what you said. So, for us, we have to go back to the concept. Now, as a 21st century commercial lawyer, relatively young, not as young as Nishan, I am not averse to the concept of making commerce popular. Yes, we have to generate growth. Yes, we have to generate income. Yes, we have to bring money in. Yes, we have to have quicker ways of dispute resolution rather than going through 10 and 15 years in court. Yes. However, is this how we want to do it? Because the next question arises. Whilst I agree with Nishan that we can have a separate system in this city place for people to have their cases heard quickly and disposed of, then what happened to the other Sri Lankan citizens within the Republic of Sri Lanka? Then is this port city not part of the Republic? So then you and I have to go and solve our disputes for 25 years in the district court. But the gentlemen who are favoured in this city can go and settle a dispute overnight over a cup of coffee. Is that what we want?
But I'm rather concerned that the way it is sort of set out now, that Sri Lanka will end up with leaders in the making of Marcos or Suharto and so on.
Yeah.
And we have strong men government when strong men government is out of play now.
Unless the people want it. I am willing to go with the people in this. I mean, if the people want that,
but it's a little bit far-fetced, isn't it, to think that just because 6.9 million people
I think so, and I
voted.
agree with you. Now, for instance, look at this, will you? His Excellency the President can now grant exemptions. President can make regulations applicable to offshore banking. Grant exemption on incentive strategic importance. Land restrictions on Alienation Act that under section 27(5) of the proposed bill that has been set out. So the restriction of foreign holding on land and all that have been taken away. Then similarly, I'm going very quickly. I don't think we have time to go into detailed analysis of it. I myself has not had a time for us to go into detail. Urban Development Authority Law Act, that is also section 65(1) of the new bill that takes it out. Now therefore, so what my principal argument to your viewer is, do you want this separate system of law that's applicable to only a certain class of persons within the Republic of Sri Lanka? If that's your will, 69 lakhs or whatever, or it may be diminished now, that may be okay. That may be okay. But as I said, I want commerce and industry to grow. But as to whether we are going to do it by violating our sovereign rights, equality of citizens, that's my question.
One of the president's key campaign slogans coming into power was "One country, one law." It would seem that this bill is in direct contradiction of one country,
but
one
not for
law.
China, the harbour city area. That's what.
Yes, sorry.
Interrupt. Whilst agreeing with what my learned friend has stated, can I draw your attention to Article 148 of the Constitution, which says that Parliament shall have full control over public finance. That's a requirement under the Constitution. Then also Article 76(1) provides that Parliament shall not abdicate its legislative powers. So the legislative powers have to be with Parliament, and Parliament also has full control over public finance. Now, having stated that, let us look at Section 53 of the proposed law. It says that the Commission can recommend to the President, His Excellency the President, as regards businesses of strategic importance. The Commission recommends, and if His Excellency the President approves it, it goes to the Minister of Finance. In consultation with the Minister of Finance, it is put to the Cabinet of Ministers. I'm trying to raise an issue arising out of that. Thereafter, it says that it has to be gazetted, and after gazetting, after a period of time, it has to be placed before Parliament for their information. Section 53(4) for their information. Now, up to now, the laws that I have looked at provides for various rules to be made, various matters to be gazetted, but having gazetted them, it has to be placed before Parliament for approval. If I may quote from a particular section of the Strategic Development Projects Law, it says that also has similar provisions, somewhat similar to what is there in this particular bill. It says every order made in terms of subsection 4 shall be placed before Parliament within 3 months from the date of publication of the order in the Gazette. For what purpose? For Parliament to either approve it or reject it. And once the order is published, if Parliament, don't forget these are all revenue measures. There are 14 enactments which are being made inapplicable. People who get involved in this structure are exempted or can be exempted from 14 enactments, of which most of them or all are revenue
It
enactments.
includes the Strategic Development Projects Act
No, before that.
and the BOI
Sorry?
and the
Yes,
and the UD
yes.
and the Municipal
Now,
Council.
Customs
And
Ordinance, Inland Revenue Act, like that, most of the 14 enactments from which you can give exemptions are revenue measures. Now, as I told you, it's Parliament which is in control of the finances of this country. So, if any exemptions are being given and they are gazetted, it has to be brought before Parliament, and Parliament will either have to approve it or disapprove it. If they disallow, up to the date of passing that resolution disallowing, it remains valid. From that date, just a minute, from that date onwards, it becomes invalid. But please look at section 53(4), which I say is an eyewash, by the people who drafted this bill, where Article 53(4) says, just a minute, 53(4) says,
Present to Parliament.
right, shall be placed before Parliament for information. There is a word of a difference between that the orders made and gazetted being placed before Parliament, where Parliament then gets the authority to either allow it or disallow it, whereas this provides it shall be placed before Parliament for information.
So, Nishant,
in other words, you bring that document and show it to the members and say, look at this, feel happy about it, that's it.
So,
in other words, the legislative powers that were given to Parliament under Article 148, sorry, the legislative powers that were given under 76(1) and the control of public finances given to Parliament under 148 is being totally ignored, and in other words, we are getting Parliament to abdicate its own powers.
So, Nishant, very interesting remarks. One remark that Krishmal made was, is this the way we want to bring such a bill? And then what Mr. Pereira said, this is completely an eyewash. So what are your thoughts on this? Now grave concerns by two learned lawyers.
The two learned lawyers have the utmost respect, and I can only comment, right? So I'm only going to comment, because this bill was not something which I got involved in drafting, but I can praise all of us on what is there in the bill. Now, in respect to what my learned friend Mr. Varnasurya said, now there is no separate legal system in this port city. I will draw, this is just for us to appraise ourselves. What it says is, if there is a dispute between the commission and an authorized person, or a commission and the resident of an occupier, there is a private dispute resolution mechanism. Now in the world, I'm a commercial lawyer, so I have been involved in several arbitrations. The arbitration is a private dispute resolution mechanism. In Sri Lanka, we have an act called Act number 5 of 1995. The High Court is empowered, which is located in the Western Province, to enforce or set aside arbitral awards. So now what does the Port City Draft Bill say? It says parties can, now if myself and Mr. Pereira want to have an agreement, we can decide to have an agreement with a dispute resolution clause, where we will say we will resolve our dispute by way of arbitration. And we can say we will have the hearing in Singapore, we will have the rules of Singapore to govern it, because it's party autonomy. Parties can decide. This is not a novel concept for Sri Lanka. We have had it here, right? So this is saying, this is 62 subsection 5 says Now this International Commercial Dispute Resolution Center, we have already an international arbitration center in this country that is unfortunately defunct for reasons unknown to all of us, but we need an arbitration center. We need to attract foreign investors to come to Sri Lanka and to resolve their disputes in our shores. Singapore is an international commercial arbitration hub. Now, we can't be saying arbitration is a bad thing. This is my personal view. I am not here to...
Nishan,
yes.
As a matter of policy though, is it a good idea? Because in the case of Singapore, these are laws that apply to all of Singapore. No matter where you are in Singapore, the same laws apply with. So, I mean, for governments making policy in countries like Sri Lanka, you should be ensuring that it's the same for
That's what I'm saying. There is no different law. It says 62 something. Now this is something I have to be brutally honest to all of you all. I also got a hold of this bill today only once. I think your organizer sent it to me and I printed it out and I read it. Right? 62.5 says the enforcement of an arbitration award made by the International Commercial Dispute Resolution Center set up under this Act shall be done in accordance with the provisions of the Arbitration Act. That is our act.
I don't think we are at
the thing is, let's say businesses outside of the economic zone.
So that is one.
No, arbitration provisions are fine. There's no problem with that. The problem is elsewhere.
Sorry, may I take 30 seconds just to clarify the point that you were trying to very smart young guy. The different, I highest respect to him. Nishan and I have appeared opposed to each other. Now, what Nishan is saying is agreed.
I don't think any one of us have a dispute.
Arbitral agreements, Nishan, correct.
Absolutely
Two parties
correct.
say, if you and I are entering a contract to import kahakudu, right? Hot topic these days, no. We can enter into an agreement and say any dispute will be settled through arbitration. That's parity between us, between the two parties. We are at liberty to engage a third party, Mr. Pereira, to arbitrate a dispute on importing kahakudu. But no one has put that into law in this country hitherto and said some area of the country by law act of Sri Lanka, in this area all disputes are going to be governed by arbitral agreement. That's the difference. Arbitration means between two parties who are free to choice. If we have to a dispute, we don't need to go to court. We agree amongst ourselves to have third man, umpire and win-win situation. Here there is a law being made for one area of the country to be governed in this. That is my problem. And once again, I don't have a problem. If the people want it, I don't have a problem. I'll go and appear for some of you if you want that to happen.
Kushmal,
that's
I
okay.
just want to...
That's a very important point. Just to add to that.
That's the difference I was trying to make.
Now that is only in respect of two aspects of disputes.
Between the commission, no?
Yes, but if you have other issues which you want in respect of the area, 63 applies. Right? 63 priority shall be given by courts. That is our courts. In relation to any legal proceeding institute on civil or commercial matters where the cause of action has arisen within the authority.
Why give priority to them?
No, so that is
what about the other residents in the country?
We shouldn't have not here.
No, I know.
I'm not here carrying a proxy.
No, we are discussing.
I'm not saying that you are here too. I am only here to set out the brain clarity. There is a law. There is provision here which says if there is a cause of action which has arisen within the port city area, you come to court.
So, Nishan, I just have...
And one more thing, just one more thing. In respect of criminal offences, can you get away with fraud or cheating done within the port city? No. Now, this bill is, I am reiterating, alien to me. Now, 68 says, 68, notwithstanding the provisions contained in any other written law, any person who within the area of the authority of the port city does blah 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 commits an offence and shall be liable on conviction after summary trial before a magistrate. Magistrate is sitting not in the port city. You can't get out of murder by doing that there.
So, Nishan, all these measures are taken in order to attract investors.
No, I don't think it is to attract investors. These sort of things are required to uphold the rule of law.
Absolutely, but this bill in question, the Colombo Port City Economic Commission bill, all of these are done with the government's attitude towards bringing forth FDIs to the country, making sure that there is economic growth, sound economic growth in the country, so on and so forth. Agreed and understood. In 2011, I want to revisit the past. In 2011, the Mahinda Rajapaksa administration took over 37 underutilized assets to the state, which was also owned by some foreign entities in the country, like the Sri Lanka Exhibition and Convention Center, which was a Singapore-based company that was holding power onto that entity at that time. So let's say, come 2025 or 2026, when the port city comes into full swing, not yet, but in 2026 or 27 onwards, what happens if the government brings forth another bill to abolish this existing bill? Then what is the confidence that would be placed on a normal investor?
Now, with all due respect, Shamir, I think governments come and they change policy. So unfortunately, that is the plight of our country, right? So I can't foresee what the government will do. If it does so, and if it repeals this act, then obviously there are going to be issues. There have been parties would have relied on this, entered, and there would have been a system in place, or there are contracts going to be entered with the commission and the authorized persons, who are the people who can deal with the commission. So those are matters which unfortunately you and I sitting here can't foresee what is going to happen in 2025. So, but if they do so, it's not good to do it, because you have to have consistent policy.
Isn't that why a national policy is important on an issue like this?
So I am not a politician. I am purely a lawyer, in the sense a commercial lawyer. So I was just looking back from 2014 to now, and I thought that all governments have seemingly felt that this port city is a requirement to elevate Sri Lanka's status from where we are. Now we are all cursing, the dollar is over 200. We don't want to aspire the dollar to be at 600 in 10 years. No, I don't think you and I or anyone here, whoever comes into power, they should not be aspiring to do that. Their aspiration should be bringing the dollar down to 100 rupees. How are they going to do that? Not by illegal means, obviously, but there has to be proper means of doing that. So attracting investors, in my personal opinion, is the only way we Sri Lanka, that is me personally placing, this is not anybody's policy, this is my thinking, we need to elevate our status. And another important point which I just, on public finance, yes.
We started off this little discussion after Mr. Pereira was pointing out that 53.4 was about
I'm going to come there.
So we agree about all these other things about arbitrary and all that business, but this point about sending it to Parliament for their information only sounds very undemocratic, and I believe would be very unappealing and unhelpful to an investor coming in, bringing their money in here.
It's unconstitutional.
And it is also unconstitutional.
Whether it is constitutional or not, with all due respect to all of us, I think the Supreme Court will decide that. I am also not here to decide that. But I need
Neither are we here to decide, but we are expressing our opinion.
So we are expressing our opinions. But I just wanted to draw everybody's attention to the bill. Section 23. Section 23 is very important. In a very short time, I had certain other work, but I thought I'll read this. Section 23 says, 23A, now how does the funds of the commission come to being? We have to appreciate, this commission gets money. Is it the money from the consolidated fund which is coming into the commission? Is it public finance which is coming into the commission? What does it say? A sum of Sri Lanka rupees 400 million being the initial contribution payable by the project company to the fund of the commission on account of the commission discharging entirely the functions of investment facilitator of the Colombo Port City, which sum shall be used by the commission to defray initial setting up operation expenditure of the commission of international promotion, Port City and Sri Lanka. So who pays this? The project company. That is the investor.
I wonder when this 400 million was...
I might be wrong. I might have missed something. But my position is, this is not money which is taken out of the consolidated fund and deposited.
What Article 148 deals with is, it says, I'll quote from the article itself, if you so desire. 148 says, Parliament shall have full control over public finance. This is once the money is coming there, it's not
becomes
the
public
monies
finance.
of an individual or a political party or a leader or the president. It becomes public finance, and this says Parliament shall have full control over public finance. And 76(1), make no mistake, it says Parliament shall not abdicate or in any manner alienate its legislative power. When an order is gazetted, it has to be brought, and these are, don't forget, these are matters dealing with revenue. In the sense, exemptions are granted in relation to an investor, in relation to 14 statutes which are revenue statutes. Once that is done, it has to be brought to Parliament, and Parliament is the final authority to decide whether it should be approved or not. That has been the practice up to now. And what are they trying to do? They are doing an eyewash and saying, yes, bring it to Parliament for their information. You don't have to bring it to Parliament for their information. I am not a parliamentarian, but if I pick up the relevant gazette, I can have that information. I mean, surely we can't play the fool with the people of this country. I said that, I don't know. Whether anyone agrees with me or not is a different matter. But I think this is a clear eyewash whereby they are trying to fool the entire nation. And I'm sure they will also be fooling the members in Parliament, because I don't think most of them will understand unless it is pointed out. Parliament is in full control of public finances. Any matter dealing with the finances, public finances, will have to be brought before Parliament. Orders which are made which affect public finance will have to be brought before Parliament, and Parliament is only has the power to either approve it or disapprove it. How can one say, how can one challenge that? That power, the Constitution says Parliament cannot abdicate, meaning Parliament cannot delegate it to anybody else. What are they trying to do? What are they trying to do?
Which is why it is unhelpful when the commission and the commissioner is appointed by one person, who happens to be the president.
Can I also say this? Please give me.
I agree.
That is not democracy.
Faraz, just give me. Please pardon me. I'm in agreement with Nishan that any good government, any government will want to expand financial activity. It will want to expand production so that monies will flow into the country. I have no quarrel about that. But the way in which you do it, you can't play the fool and use words the way you want and get over certain constitutional provisions. That's the thing
the point I was trying to make is, when Nishan says that monies are not from the consolidated fund and are raised outside of it, that is not what we are trying to say. That's what we must understand. Sri Lanka, qua republic, as a republic, don't permit individuals or corporate entities, however big or small they may be, to come and generate their own money and spend it in any way they want and then make profit on it and go out. That's why the Constitution is clear. All fiscal policy, not part of the fiscal policy. Fiscal policy is generating income or revenue on behalf of the republic and spending it on behalf of the republic. All of that must be scrutinized by Parliament and no other. So when you make law that goes to surpass that, then as Nishan says, I'm sure we will have to visit this question one in the Supreme Court and say, well, is the people's judicial power going to permit this? That's ultimately there. No. People's sovereign power in Parliament. If Parliament wants to abdicate its power now, as Mr. Perra says, Parliament says, okay, let's give it to the port city. You all do that part of it. It's generated privately, no, so you all look after that part of the money. We'll look after the other part of the poverty alleviation in our country. That's fine. So let one part become rich, other part become poor. If Parliament wants to do it, then like people's representatives, you all have elected and sent. So if that's what you want, that's fine. But it's not fine for me, but if that's what the majority wants, that's fine. Then it's still not fine, but there's nothing I can do about it. But when the Supreme Court looks at it from the judicial power of people's point of view, whether the Supreme Court will permit this, when the Constitution says all fiscal policy, all income and expenditure must be governed by the Parliament, But Port City, let the president have an audit report and then bring it to the parliament and show hello here for information. If that's constitutional, then I'm sure we'll get a verdict on it when we go there, if and when we go there.
So
But,
there's a question
Krishna,
for...
there's yet another unhelpful matter. In this proposed act, it says that the people who work there will be paid in dollars.
Yeah.
Okay, that's great, wonderful. I wonder then why this bit here just now, it says that the project company will pay Sri Lanka rupees 400 million. Why? Why in rupees? If we're all going to talk in dollars before, and is it $1.9 million like it is perhaps today, or is it 2.2 million when it was a few weeks ago, or maybe 3 million if we take it at 130? So what is the whole point? It seems to me very unhelpful when on one side you're talking in dollars and the other side you're talking about Sri Lanka rupees.
Is that rocket science for us to figure out with the deficit between foreign revenue and our rupee going sky high at the rate that we are? They would rather spend in rupees, anyone rather spend in rupees, keep the dollar on the payment, and let's deal in rupees domestically. So
but there's
surely,
also further clarification needed. For example, if you're being paid in dollars, what happens to your EPF ETF account? Is that going to be, we'll need new rules then to set up a dollar fund so that people who get paid in dollars in the port city can then have their EPF ETF paid in dollars? And then who's going to be in charge of that? Will the government then dip into that to show up our reserves?
To address that, I think there is the provision very clearly set out where regulations can be brought in from time and time again. So, as I said, I look at this in in all due utmost respect to my learned friend Mr. Pereira and also Mr. Varnasuriya. Their positions and their thinking, I don't want to differ and argue with them, but it's just my opinion is that this is work in progress. So we have to admire, not that this bill is perfect, we have to admire that from 2014 there were talks about this, then 2015 to 2019 there were continued talks about this, and now there is something on paper which you and us and we all are sitting here at 10:30 in the night and debating on. So there is some progressive step taken in bringing in a regulatory framework for this filling or the port city which we continue to see at the Gulf West front. So now, as Mr. Varnasuriya or as Krishmal says, whether this bill is constitutional or not is a matter for the Supreme Court to decide. Whether the provisions which Mr. Pereira say is unconstitutional or whether my thinking is something which the Supreme Court will hold is a matter which I believe we all will have to wait and see. When the 20th Amendment was brought in, I think the Supreme Court struck down many articles and modified many articles, and ultimately what was brought in by this government was not what was passed. But yes, Mr. Pereira has differences and he says he has valid reasoning and argument for that. So we will have to wait and see. But addressing your question, I think there is flexibility also in the bill where regulations can be brought from time to time where all of these matters can be streamlined.
So we have a question.
We need to get the structure right though. We need to get the basic structure.
Yes, so that is why
so that's the part where
that is
we
this
go
bill.
back to 53.4 for information only. That's a big red flag.
So it's a point of how do I put it? It's my opinion.
If you're not colorblind, that's a big red flag.
I personally, because the commission has to be audited in terms of Article 154P of the Constitution. That is also provided.
The audit report goes to the president.
But it is provided that it has to be audited.
Yes. Yeah.
That is correct. But now we all can sit here and argue till the cows come home, right? But now we are in a system, good or bad. There is so many appointments done by the president, and I am not an adversary of that. I don't promote that, right? I don't believe this immunity for president is a healthy thing. But even the 20th Amendment has certain degree of, certain administrative acts can be still challenged, which has been effected by the president. So,
Sonali, you have any questions?
Yes, can I just say one thing?
Yeah.
I differ with what was stated by my good friend Krishmal when he said there's a popular conception that there is a two-thirds majority that this government has got. They do not have a two-thirds majority. They got only 148 members in parliament out of 225, which is less than two-thirds. It is just that 8 members, a female, Sinhala female, a Tamil member and 6 other Muslim members, I believe, who got their votes from a different party for reasons unknown to us. They voted in favor, and that's how the two-thirds was made. There's a popular conception that this government has a two-thirds majority. No, it does not have a two-thirds majority.
Mr. Varnasurya, whilst it's important to drive economic growth and structural transformation, and Sri Lanka needs to sort of compete internationally as a regional trade and business destination, we need a coherent policy framework surrounding Port City, which we all recognize. However, I'd like you to revisit the proposed bill's wide-ranging powers for the high-powered commission. Now, my question to you is with regard to the checks and balances, as it seems to be absolute power that vests in them. If we were to compare this with one of the success stories of the special economic zone in Dubai, it's governed by 3 independent bodies, one of which is the Dubai Financial Services Authority, which is a central and independent regulator that grants licenses, oversees activities of all financial and non-financial institutions, regulates all financial and ancillary services conducted in the center, including disclosure requirements, and it goes on. So the importance of having an independent body to oversee. I mean, we got rid of our independent commissions by repealing the 19th Amendment as well. So speak to us about the dangers, the potential dangers that this high-powered commission would pose.
Yeah, thank you, Sonali. Will you permit me 30 seconds just to answer Mr. Pereira's deference of my... No, I have to. There are people watching this, no? Majorities in parliament are made by the actual number of heads sitting in government or opposition. As to whether they flew over the cuckoo's nest, jumped over, crossed the well of the house, or bought over, numbers in parliament is what makes a majority. I agree with Mr. Pereira, when the election was over, the government didn't have two-thirds. However, we must all remember, by hook or by crook, the government has managed to show a two-thirds. And that's what I meant when I said they had a two-thirds to get the voting process through. Now, as to whether it's legal or illegal, democratic or undemocratic, you the people must decide. I remember several years ago, we tried to bring in a crossover provision to a 19th Amendment also, which was never passed by everyone in that house. So, you the people who ultimately decide must decide whether you are going to permit crossing over or not. Thank you, Sonali. I took 30 seconds.
By hook
yes, now, okay. Let me get to the answer. Sonali, this question that you posed is a very important one. This was answered by one of their Lordship, the Chief Justices, when in the 17th Amendment. I was a young lawyer then, junior counsel, right at the bottom of the list, appearing in the case, I think way back in around 2001, 2002, if I remember correctly, when the then Constitutional Council, it was not a commission but council, was supposed to be given immunity from checks by the law. And in their determination, the lordships say, we are governed by a republican structure of government that cannot have anyone above the rule of law. Above the rule of law. And therefore, when you make a creature, because there the intention was that they'll make them unaccountable even to the Supreme Court or Court of Appeal under writ and FR jurisdiction. That also was taken up. And their lordship said, no, we can't have any creature above the rule of law. It's a rule of law that governs our republic. So that's the concept from which, Sonali, we must visit this question. So if as I also have seen by a cursory reading of the massive powers of the commission, they appear to be a law unto themselves, which are unchecked and untrammeled by such other commissions, including so-called independent commissions that are subject to law. Now, once again, that we must decide whether that is the rule that we want our country to govern by, to be governed by. That's what we need to decide. So, I agree with you. To me, it looks excessive. But once again, as you said, Dubai. But Dubai, of course, it's by a central regulatory authority. And if I know the little bit of Dubai law that I know, the laws that govern commercial transactions are ultimately subject to the laws of Dubai. That is why, if you remember some time back, when one of our excellencies, the presidents, wanted to send a note to the Sheikh saying, give certain details of bank accounts of some people, you know, my friend can, and they said, no. There is a law that governs. Just because head of state sends a note to another head of state, I am not going to give this information, you need to bring a court order. You need to be, because banking law is very strict. Banking law, you can't disclose information to third parties without a court order, or if the party, that's a customer, says okay. That's why we went wrong there. So, although as you say, yes, Dubai has thrived as a hub and as a commercial hub at that, they have still maintained the sanctity of the law. They don't overarch it. But here in the port city bill as we see it, I hope our learned friends who are drafting this, I don't know who, little birds here and there tell us who have been drafting this. I'm sure Nishan knows more than I.
No, I don't know.
I hope they will revisit these questions.
As we're on the subject of Dubai, Nishan, we have a question from freelance journalist Srinath Fernando. At Dubai Arbitration Court, foreign lawyers can appear. Will Sri Lanka also allow foreign lawyers if it is to attract foreign investors?
Now, that is a question which I have fully promoted, because arbitration is not a court. We are getting all of this mixed up. I have gone and appeared in London. I have appeared in Singapore, in SIAC, in ICSID. I am a Sri Lankan lawyer. I have advised and appeared for clients in ICSID arbitrations in England, in SIAC arbitrations in Singapore, because that is a private dispute resolution forum. My learned friends will agree on that. There is no, I don't need to get a license from Singapore to go and sit in an arbitration in Singapore. But I can't go to the Singapore court and appear to set aside an arbitral award in Singapore. I can't do that. For that, we have obtained legal services from the Singaporean lawyers. So, that should be how, that is progressive thinking. We should be able, that's what I'm saying, we should get Sri Lanka to be the commercial arbitration hub in, we call ourselves the pearl of the Indian Ocean. We say that. But what are we attracting? We should be able to, arbitration is something we counsel, we love, because we get to go to a foreign destination, we get to stay there for a few days, hearings are there, we get paid in currency, I don't want to mention that, but we paid, we love the whole, we meet foreigners, it's a tremendous experience.
That's only part of lawyers.
But Samir, I want to clarify the difference.
Okay.
So just to add to that, now we have so much of surroundings and beauty in our country with the arbitrators and litigants and counsel coming here won't merely stay for a couple of days. Now, so in private forums, we should, there is no bar even under the Sri Lankan law for a Singaporean lawyer to come and appear in an arbitration. There is no bar. Not that I am aware of. You all can correct me.
Right.
There is no bar. There is no bar in Sri Lanka even now for arbitrations where we have. I have been in an arbitration in a Sri Lankan forum.
You're right.
Where we have had foreign lawyers coming. So it is not a new thing. This is, when I looked at this, I was also. I firstly thought, how am I going to come here and with all of you all sitting here, I am not here to defend this, mind you, that we all have to be very clear, I am not here to defend this, I am here to put the things into perspective in my understanding. That is why I am here. Now, there is no separate law, I can't see this law. I don't know whether I am blinded.
May I take a minute just to once again, so that...
And then I'll come to Mr.
Yes, so that your viewer doesn't get confused.
Yeah.
What Nishan is speaking of are arbitration agreements. All of us have appeared. Now these days there were some ICC cricket arbitrations where we are also appearing before foreign tribunals and foreign lawyers, foreign judges. All of that is fine. But those are agreements between two parties. Once again, be very clear. Private entities, not a republic, not a commission of a country made by law of a parliament. Two parties who agree, we will have arbitration, for example, at the London Centre for Arbitration. Then it's governed by the London Commercial Arbitration Centre's rules. That governs what law, how the evidence will be led, how cross-examination will be done, how your representations, lawyers will represent you. That's governed by a private agreement. Now we are speaking of a bill that's before a legislative assembly, the parliament, to make a law for a separate area of this republic, for a law to be encumbered upon everyone that is subject to that jurisdiction. That is different, and that your viewer, I hope, will bear in mind the two differences in arbitration between two parties who are, as I said, importing kahakudu from somewhere, and law being made in a country to apply for a certain area where something is to apply. That's the difference.
Can I raise one other issue? Section 37(1) and Section 64(1) of the proposed bill. 37(1) provides that the Commission can authorize an authorized person. Authorized person is a person who is registered within the zone to engage in business in Sri Lanka with a citizen of Sri Lanka or resident who is engaged in business in Sri Lanka. Business has been defined to mean any business, right? Then 64(1) provides that the Commission can permit an authorized person who is registered, to engage in business from a designated location in Sri Lanka outside the area of authority for a period up to 5 years. Now see, once I register myself there, I don't have to restrict myself to that zone. I can do business outside, right? Enjoying all the privileges which are given to me as exemptions under the law. Now, the other businessmen who are operating outside this zone will have to compete within Sri Lanka, outside the zone, compete without having the benefits or the privileges of the exemptions that have been enjoyed by that other person. Should we permit this? I don't know, I'm raising the issue. I mean, on the one hand, the persons who are registered there, it's not everybody who can register. The Commission will decide.
Yes.
We know this is a corrupt country. So therefore, who will be given registration, who will not be given? If I, being a man who is opposing the government, I can assure you I will never get my, very likely I will not get, I wouldn't say assure, I will probably not get registration. The man who gets registration enjoys the privileges of revenue enactments not being made applicable to him, including customs law, inland revenue and such other laws, right? As against that, he not only restricts his business to the zone, but he can, under 37(1) and 64(1), go outside and do business, competing with our local businessmen who do not enjoy that privilege. I think that is not an equal ground which is
along those lines, considering what Mr. Pereira is saying and what Krishmal has also said, I know you said that you're not here to defend the bill itself, but perhaps you can give us, does this bill translate into good policy? Is it, for example, in line with the President's vision of one country, one law, given what Mr. Pereira has said as well?
With all due respect, I don't know about the President's vision, in the sense that is not something I'm personally possessed of, but I can speak on the bill. So on the bill, if we look at the flip side of this, is something probably
avoiding the legalese.
I think Nishan is going to talk about the flip side of the bill.
Yeah. Just you know, this is the important point Mr. Pereira brought up. Probably this is something we all have to look into, this aspect, whether merely by getting your approval to do business within the port city territory, can you then, and on the notion which Mr. Pereira says, which we have to agree that so many things in our country seemingly doesn't happen without spending money at the proper places, right? Unfortunately, that has been where we are for the last so many years. So does this give a free license to an entity to walk out of the port city, set up and engage in business activity outside the territory without getting the required approvals under the local laws or under the laws of the country is a question. So that is a matter of interpretation. Now I said, what did I say? I said, we look at the flip side. Now there is also in this bill where it says that if say a bank wants to get its license to set up its bank in the port city, a bank has to have initially obtained its license under the Banking Act of Sri Lanka. So it has to firstly get its license to do business in Sri Lanka, and then it has to apply to the commission.
Accepting, Nishan, that the local banks can't raise Sri Lankan money. They have to bring overseas money, foreign money.
I'm just talking about getting the license to set up office within the port city. I'm not possessed of that. I'm just answering the I'm looking at how outsiders can come and do business inside.
Farhad, I think you're right, because there's express provision which says that if you, even though you may have foreign reserves in Sri Lanka, those foreign reserves cannot be made use of. It must come from outside.
And the other aspect,
no domestic bank will be allowed to fund investments in local currency.
So there might be something, I don't know. I don't know the purposive, there in drafting legislature, we have so many principles of interpretation also. The purposive mischief rule, the purposive rule, the literal rule. So we don't know what mischief the legislatures intended, but the draftsman intended. So ultimately when it goes to parliament, or before it goes to parliament, these matters can be questioned.
No, but the question that Mr. Pereira brought forth, saying if the government doesn't like, or if this commission doesn't like someone's face, they can reject them. Can they?
Yeah, so you can be rejected under any body of our country. You can be rejected with a BOI.
Someone decides on that.
Yeah.
Based on the discretion of an individual or a commission, is that fair?
So now, subject to, my knowledge in admin law is I believe sufficient, but not as good as my two learned friends.
No,
right? But
equally good.
But there are principles. Our Sri Lankan courts have evolved principles of judicial review over a period of time. Now we have the public interest doctrine, we have doctrine of proportionality, Wensbury reasonableness. So even there's a recent judgment where even private body, which the power is devolved through a statutory institute, can be subject to judicial review.
Of course, it's just 2 minutes ago that my good friend said that getting into litigation in Sri Lanka can drag on for years and years, which no investor will be willing to take the risk of.
No, that is correct. But
so whatever protections on paper that we may have, as it was quite rightly pointed out by my learned friend, my good friend, that once you get into litigation, that's why he was trying to justify the arbitration clauses, because he said if you go to court, you hang on there for years and years. So if there is a violation of what has been done, then you go to our normal courts where you will be hanging on for years and years, and no man who wants to risk his money would want to take that.
I'm fully in agreement.
So
but the simple point.
Yeah. That's a question I'm posing to you. Nishan is right. The idea is, now he said he used the words in the act, that courts must give priority to litigation against this commission that comes from the port city problem. Now, is it then equal for the rest of Sri Lanka to go through the laborious process of litigation, 20, 30 or 40 years, or give priority to some investment problems that come from this port city? Because why? Because they have paid more money, or because they are a select class of people? The answer to my question that posed to me by Sonali, a different class of people, different class of persons. Now, Isn't that why, Nishan, we made the commercial high court some time back, long time back, saying commercial disputes must be resolved quickly. Therefore, we must change the High Court of the Provinces Act, saying first it was I think 3 million, now we have raised the bar a little bit. Disputes of a commercial nature, commercial high court must quickly settle. Now that also unfortunately is prolonging. So, is the answer then, once again policy, I'm talking about, is the answer then to create another port city bill that say, okay, let's give priority to disputes coming from there which are over these millions of dollars or Chinese yuan or whatever, or do we change the system that we have to make a litigation process more quicker, more speedier, so that everyone gets quick litigation? Why should it be only for investors in the port city that courts must give priority for their cases to be quickly heard? Boy, what about Krishma Varnasuri or Srinath Pera or Nishan Premathratha for that matter? Or Shamir Rasuli or Sonali Manipurgi or Nadeem Majid or Farah Sokotali. When we go to court, so we must wait the normal process in the queue. But when you come from port city, you must give priority. Why? What's good for the gander must be good for the goose. That's a question that we must ask. As we said, we must visit it. That's the question we must visit.
Mr. Varnasuri,
Can I-
now these days specifically,
Sorry,
Nishan, I'll give you an opportunity to.
because
I will. Don't
Okay.
worry. But let's
there's
listen to Sonali
a
and-
massive outcry, especially these days, about the environmental destruction and ecological justice aspects. I'd like to draw your attention to section 6J of the proposed law. I'll read it out. Section 6J. I'll read it out for the benefit of our viewers. The Commission has a power to develop and approve environmental standards and plan and monitor and execute environmental improvements as may be required within the area of authority of the Colombo Port City. So the Commission will have power to both develop and approve environmental standards. It struck me as a bit odd that the same Commission that has the power to develop an environmental standard can also then approve it. Can you speak to us about whether this does not contradict with the existing frameworks that we have, especially given the fact that when this Port City project was coming up, we had massive conversations about the environmental impact assessments, whether they were being conducted properly.
The sand dunes.
Absolutely.
So, Sonali, once again, now I didn't, the section you read, if they have exempted the National Environmental Authority Act of Sri Lanka and other environmental regulations, I will be concerned. I read customs ordinance and several other here. I haven't gone through the whole list. Maybe my learned friends can elucidate on this point. Has the National Environmental Authority Act been also subject to qualifications in this act? Because Sonali, in the rest of the Republic up to now, as you well know, we need to get a preliminary environmental assessment done to make any project. Then if it goes beyond that, then it goes to a further environmental impact assessment. There are 3 steps in the process, and it's subject to passing all that. If you remember correctly, some of those Southern Expressway and Northern Expressway cases that we did, even people have to be interviewed, temples have to be visited, reports have to be taken from neighborhoods to see whether this proposed development project is actually conducive to the environment. Now, the question is whether all those laws are going to be forestalled by this Commission overriding what they, as you said, they will come out with a proposal, then they will approve it, or whether the environmental regulations that govern the rest of the country are also going to be applicable. If they are, I will have no problem. If there is clarity in this bill that the central environmental regulations of the Republic will also be applicable to these projects, I have no problem with it. But if they are to be superseded or overridden or suspended, then I'll have a problem. Because it's not just their environmental that we govern, the rest of us will also have to live and breathe this air.
Nishan, you want to add something to what
Yeah,
Pushpa
so no,
said?
I think the esteemed senior learned, my learned friends, they answered your question. The high-powered committee or the commission, notwithstanding, is amenable to scrutiny by the judiciary, and judicial review is possible. If they don't like the face of the investor, if they reject it, there are remedies. If they were unreasonable, if they were arbitrary, there are remedies. And also, if you look at the BOI Act, recently I was in court and I was taken up, there was an objection taken against me. I didn't know that the company was a BOI company, and I had got an ex parte enjoined. My client didn't know. Ex parte, the BOI Act says you can't get ex parte enjoining orders, ex parte orders against the BOI entity. So now, even something of that nature is not found here. I didn't find it. I don't know whether I have missed it. There are no ouster clauses found here where jurisdiction of court has been ousted in any way, or any way to intimate that the Commission's decisions are final and binding on parties. Notwithstanding, even with ouster clauses, our courts have held that these administrative bodies are subject to judicial review. So the Superpower Commission is still within the purview of the rule of law and Article 3 and Article 4 of our Constitution. In that context, I say, in my humble opinion, has not been violated.
My quick response to that will be that the general language of the Act, which says that disputes will be governed in that area subject to the laws that pertain to that port city, will act as a ouster in general in reading of several of the provisions. Although there may not be a specific ouster clause saying courts can't hear our disputes, by applying one law to one area of a land, it will, I have to, once again, as Nishan said, we have to study this in detail. It may apply as a ouster, and people will take objection saying, how are you hearing this case? This case should be heard under the laws applicable to this area.
So Nishan, making black money white, now that's one of the major concerns that many people have with regard to the port city. Would this happen?
So that's why I pointed out pointed out to the regulatory or the criminal provisions which are also governing the transactions and everything which is happening within the port city. So if there is money laundering, and that can be construed to be falling within the purview of the offence, it's my personal view that you can try that, and the magistrate court or the high court can take cognizance of the offence. And I don't think the port city where one of you all or me walking down the road and I bump into a foreigner and that guy or a police officer in the port city jumps on me there, I am left with nothing to do. There are no legal remedies, and it doesn't work in that mindset to me. To me, all of that is clear. You can come to the magistrate court. The minister obviously will have to set out the territorial zones, and all offences will have to be subject to what my learned friend.
I wish to point out just one thing. Schedule 2, which consists of the statutes in relation to exemptions can be granted, includes the Foreign Exchange Act.
Yeah, so with all due respect, the Foreign Exchange Act is not
Item number 13.
It doesn't envisage the Money Laundering Act, which is an offence.
Item number 13.
Foreign Exchange Act is, to me, a different element.
Foreign Exchange Act is there to control.
That is correct.
Right? Now, once you grant exemptions, where do we go?
So that is a different point. I am not on that point. So my learned friend has a different point. So,
no, but that's a valid point.
No, that is a different. Now, when BOI grants BOI approvals, you get exemptions. You don't need to pay taxes for, if you are a Section 16 or a Section 15 company. You are exempted from taxes.
For a period.
Yeah, for a period. That is there. So in the government in the recent budget also gave tax exemption to so many
and these exemptions can be granted up to 40 years. That is for 2 generations to come. We grant the exemption, 2 generations of Sri Lankans will be bound by that. They cannot change it. Agreements are entered into. Once these agreements are entered into, we are bound by that, and thereafter our children will not be able to get out of this trap for 40 years.
And these exemptions will be granted by one person or
Absolutely.
a few people appointed by one person.
Absolutely. Absolutely.
So
I must make it very clear. I reiterate and say, any government would want to expand its economic activities. Hands down, we salute. But when you do that, we have to ensure that it will not result in mortgaging our rights to various investors all over. So therefore, I hope and pray that this government will take into consideration these critical areas which are pointed out, and iron them out and ensure that these provisions which may be
So Nishan, right now as you speak, the government is earmarking $1 billion to flow into the country this year through the Port City project. And PricewaterhouseCoopers says that when the Port City project is completed, they are earmarking $11.8 billion US dollars to flow into the country. Would this commission in question have a say on what projects to execute and what not?
So I think the Commission's powers have been very clearly set out in Section 6. Now, whether this has to be expanded, muted, is a different matter. But I think the Commission has been given, at least there is on paper.
Now, who decides? Who decides
So the
on what projects to be completed or started or carried out? Who decides on that?
That is a very good question, because, you know, I believe for any person who is, say, hypothetically appointed by the President, who wants to sit on this committee, and then they grant a project to a party, then ultimately, at the instance of a change of government, that party also, everybody can be summoned there to the FCID or to any entity and questioned. So there has to be clear guidelines on how granting of contracts and infusing capital ought to be done.
So don't you think, Nishan, the best way to move forward in a country like Sri Lanka is amend the BOI Act, okay, and then implement the same act in this special economic zone as well? Why not? If the BOI covers most of these areas and has been debated about in the last few decades, why not implement the same regulations to the port city as well through the BOI? Matter is done and dusted.
I don't know which of my learned friends mentioned, but the BOI started off, and now the BOI unfortunately has not been a success story. But that should not be a reason to answer your question. So whether the BOI can take on a territorial or create or to act and expand its powers into a specific economic zone is a matter which probably can be pondered upon. But I'm trying to be the devil's advocate. Now, I don't know if something has been implemented and it has failed, like the BOI. Seemingly people are saying the BOI has not been successful. The one-stop shop is also not working anymore. And some say there is corruption there.
There's corruption. That's why I think it has been a failure.
Yeah.
Can I, in fairness, point out the fact that Section 66 of the proposed bill provides that agreements that have been entered into under the BOI Act must be, once this law comes into operation, must be treated as agreements entered into between the Commission. So in fairness, I think I should point it out.
I found the answer to what you were looking for. If you look at Clause 3, I managed to download it on the phone. I'm sorry, I didn't have hotspot on this. Clause 3, subclause 4 of the proposed bill. Now see the wording. This is the danger that we must try and avoid when this becomes law, if we can. The Commission shall be responsible for preparing, developing, amending, updating, publishing all community rules and development control for that area. Right? Then when they go to do that, what do? Subclause 5 of 3. The Commission shall, in the exercise, performance, discharge powers and duties, where so required, so when they need to, by written laws applicable to the country regulatory authority, obtain the concurrence of the regulatory authority. So they need to obtain concurrence of that, say for example environment. Now there is a proviso, provided that the concurrence of the relevant regulatory authority sought shall be limited to the implementation within the area of authority of the Colombo Port City of the respective written laws applicable to. So now you are making written laws that are made for the Republic, implementation restricted in a different form to one part of the country. Pray why? Why the rest of us are black? I am sure in comparison we may be not Chinese, Sri Lanka. Yeah. Anyway, now then 6, the relevant regulator from which such concurrence is being sought. Now there is some more. the relevant regulatory authority from whom such concurrence is being brought by the Commission shall, as soon as practicable in the circumstances, as a matter of priority, provide such concurrence to the Commission. So what about citizen, I'm sorry, I used the wrong word, say citizen Silva or citizen Ponnadure, shouldn't they get priority? Because they don't have millions of dollars to invest, then they don't get priority with the regulatory authority. Because you are from Port City, you get priority. So these are the questions that we need to carefully look at when we visit a bill of this nature. As we all three of us agree, we know that this country must be geared towards greater generation of income. We all know that we must find a way to do it. But is this the way to do it? Is the question that we as citizens, as I said, the minority who may be thinking of policy, may we wish to visit.
Nishan, now interesting point that Krishmal brings forth. Are we black? Is that why?
Yeah.
Is that why our cases are not being heard first? Why is priority being given only to the cases at the Port City?
So actually, when I was coming, I don't know, I got that some vision came to me, and I actually got ready for this question. I have to be brutally honest. Now, today I'm the convener of the committee which is drafting the small claims court bill, right? So we presented it to the minister. So that is for quantum below 1.2 million, an exclusive courthouse to be set up throughout the entire island, right? So the minister is going to be given the power to gazette. Now why? Now this is for the people who we claim are black, small people, 1.2 million disputes. The hearing, this act was, I'm convener of the committee, it's chaired by Court of Appeal judge. Within 1 year and 18 months, the dispute has to be heard. The Small Claims Court Act has specifically set out. Then the appeal,
the Constitution says that fundamental rights application should be completed within 1
but
year.
that is right. We are all, I have been shouting over laws delays for a long time, but we have tried to find mechanisms to take out us lawyers who actually work to delay this process. We have to concede to that. We have so many objections we can take. Framing issues in a case means about 3 appeals to the higher forum. So ultimately the black and white answer also has to come, point back to us professionals also. We take dates, personal grounds are moved, senior counsel are in different courthouses. So we have to all take the blame also. But to address this black and white issue, we have a small claims court also. Now I am also the consultant to the ministry in respect of commercial law reforms. What we are doing? We are setting up an investor dispute division of the Commercial High Court. That is for exclusively hearing disputes over 100 million. Now why no one can, now Mr. Varmasurya might come back and ask me, why are you having another division in the Commercial High Court? But at least to streamline certain cases, we are.
No, I won't ask you. You know why? Because it's the Commercial High Court of the Republic, where everyone can.
That is
everyone
correct.
Who has an investment dispute over 100 million can go there.
Yeah.
My problem is having a separate law for one area of the land.
No, so
that's my problem.
No,
I won't ask that question. If you say, okay, no, I agree with you. 3 million, 1996 amendment to the High Court Act, in 1996, 3 million may have looked big. But now, there are rich lawyers, unlike us, who deal in hundreds of millions. So, even those lawyers may...
3 million is small money, is it?
No, for us, little people like us.
Now it's 20 million.
Yes, so now it's 20 million.
20 million as per the gazette.
There are now people who deal in 100 million, 1000 million.
Yeah.
So for them, we must have a separate court, but then that's applicable to everyone who deals over 100,000 million anywhere in the country.
So I'm fully in agreement to a certain aspect of what my learned friend said, but now what we need to appreciate is when this bill goes through all of this process and criticisms and come out, we probably will have at least, now the budget has, now I'm not carrying a proxy for anyone, right? Please appreciate this. I am not.
Neither do we.
No, but I am not drawing aspersions also. So I am reiterating that because it might be perceived that I am trying to speak on behalf of X or Y or Z. I am not. But the minister or the ministry has got a 9 billion budget right? So we are expanding, trying to use all of this to work on this legal system in order to expedite processes. So when my learned friends told me, you can say 18 months, Mr. Pereira pointed out, Supreme Court says FR 3 months. We have addressed all of that in the small claims court. Now, sir, we have taken out framing of issues. Issue framing has been exclusively given to the judge. The judge has been given the power to dispense of the case on the pleadings alone. So all these matters are taking away us lawyers interfering and promulgating delays. So I believe that when this, this is a marketing tool, we have to also be able to pitch something to our investors. I personally believe investors also want to know when they or how long it will take for them to resolve a dispute. When a client comes to us, they ask us questions. How long do we have to wait in court to resolve a dispute? Now, can we give an answer? I don't think Mr. Pereira can.
I always say 20 years.
20 years, he says. Right?
No, there is an answer to what, something close to what Nishan saying. Shamir, you posed this question earlier. The question was posed about His Excellency the President when he came in, his master plan for rapid development and all that. There is another side of this for us that we must also consider. See, the proposed clause 4 of this proposed bill. Now the master plan for any project approved by the Commission will be submitted to the President with the concurrence of the President. Then the Commission shall, in consultation with the project company, subclause 2, with the concurrence of the President. So now here, His Excellency the President, the head of state, is getting directly involved in the feasibility of these projects and all that. There may be a reason for this. Because we've heard when ministers are given in the President's executive power, when divided amongst the cabinet, the ministers are given, there were 10%, 20%, 30% talks up to now that you can't get anything done without giving so and so 10 or 20 or 30%. So now the President may have actually thought, in furtherance to what you were asking earlier, no, I'm going to take all this by myself and do it. So no 10, 30, 40%.
Of course, he has the option to give it to a minister.
Yeah, he has the option,
that's correct.
But at least it's given to him, no. It's given to the President. Then it's the President that so that may be also reason. We must look at the other side. So His Excellency must be thinking, okay, I am not going to trust anyone. I'm going to take this over and do it.
So then there won't be any tile tax issues, sugar scams.
Yes, that's good, no.
Oil.
That's good, no.
Oil being brought to the country.
So then we are going back. Yes, good. Now see, then we are going back to the royal concept that king can do no wrong. Sovereignty lies in a king. So that we don't need democracy or rule of law, where everyone, including the President, is subject to the rule of law. Now we are going, so we are making, perhaps we are making a concept, President can do no wrong. Like the king can do no wrong in England. King can do no wrong because divine power comes, I am destined to rule you, so I rule you, I will do no wrong. Maybe that's where we want the republic to go. I mean, that's a reading of it that I get. I don't trust, giving out powers to others. I will do it myself.
Sorry, Shamir, I want to say this. We've been discussing this whole issue from about 9:30, and it's almost as though everyone is agreed that this government will be in power for a day and forever and a day. There's been no discussion whatsoever that I've read in the press or heard on TV or radio that this government that is committing Sri Lanka to so many years ahead, there is no suggestion that they are having a discussion with the current opposition, who may one day be in charge of this country, with the legacy that is being created by this government.
Now, that is why we said, for us, I don't know whether you heard, but we said that is why it's important to have a national policy in play, and that policy should be debated with opposition parties and widely discussed as a white paper first. That is the notion generally. When a bill is being brought forward, Nishan, the issue right now is they just passed it in cabinet and then tabled in parliament. Rather than that, open it to the public, let media like organizations like us criticize and bring forth opinion about that bill first, and then let the minister in charge of that particular subject answer, and then bring in amendments and formulate a bill, and then send it to the cabinet, get approval, and then direct it to the parliament. Now that is not happening, unfortunately.
That is not happening.
No, that's a valid point. Where they say in old concept of political science, we all know that opposition is supposed to be breathing down the neck of a government. Meaning you're so close that, you know, tomorrow you fail, I form government. That's what opposition should be. Now, I am sorry. I also associate both government and opposition learned friends and other friends of parliament. I can't see that cogent force of taking things like this, asking these questions, what we are doing now. Your station is doing a creditable job. At least you're taking this to the public. This is what the opposition should be doing. Holding seminars, discussing this bill, saying, hello, this part is good. This is generating revenue. But this part is bad. That's what the opposition should be doing. I can't see them doing it.
And none of the media organizations or even the papers are discussing extensively about the Colombo Port City Economic Commission bill at present, Nishan. So this is a problem.
No, I don't know what we are doing. No, we are all discussing.
So we're
this
doing it
and
right
we are
now
opposition
as a
also.
station.
We are not.
Yeah.
We are not opposition. But now I think, with all due respect, now the bill has been placed. I don't know, has it been placed on the
I
order
don't
paper?
think it's on the order paper.
It's not
No,
yet on the order paper.
It has been approved by the Cabinet of
It has been
Ministers.
approved by the cabinet. So
On the 24th
when
of
it is
March.
placed on order paper,
We have 7
then we have everyone, you, I, we all will have the right to challenge this in the Supreme Court, and then it can be subject to scrutiny. Bill is out there.
Yeah, but the Supreme Court, what it decides is a constitutionality.
That is correct. I am fully with you.
Yeah.
I'm not disputing that,
Yeah.
and I am fully possessed of your argument also.
And when the government is having a clear majority in Parliament, such a bill will go through, Nishan.
That is
Now,
correct.
that is the problem. Now, it is not open for public debate. People don't have a right. Now, not everyone would go to courts, because going to courts means it's an expense.
Definitely.
I don't think Mr. Pereira or Mr. Varunasuriya, I know Mr. Varunasuriya and Mr. Pereira have gone to courts pro bono on many issues, but on an issue like this, councils have to be paid. And who is going to take that responsibility? It's not a white paper. It comes to cabinet, comes to parliament. The Supreme Court will debate whether it's constitutional or not, and then it will be passed. What does the public have to say?
Sami,
Absolutely nothing.
Unfortunately,
we can't also blame the government. You know why? I'll
Yeah.
tell you something, Sami. You know why? I'm speaking on the other side of the coin. Our public are not interested, Sami. You ask how many members of your public, yes, your erudite audience that speaks English are now staying up tonight and watching us, because they engage in commerce and industry, and this is important to them. 90% of our country, Sami, you go and ask them tomorrow, Port City bill ගැන දන්නවද? Huh?
You are saying that.
The lawyers
Our
are
people
done.
are not interested.
I asked a few lawyers
I also
about
did that.
the 20th Amendment.
There you go.
Some of them did not know.
Now,
the effect of
governments are a reflection of the people, no? Governments are a reflection of the people's psyche, the people's thinking. So we need to find a way. I don't know if the opposition is not doing it, the government is, politicians won't do it, because so as long as the people remain dumb to everything that's happening, it's very good for them. They can go before election and give a badu bag and come to power. They won't do it. But we have to find a way. You who sitting in the armchair, thinking that a few of us can come on TV in the night, I've said this at your station several times, that we are going to change the country if you free Nath, Nishan, me. We are not going to do this. You have to go out, talk to your man who brings your bread in the morning, the maid who may be working for you, the community that you engage with. Hello, do you all know? There's something called Port City Bill. You have to go and talk to them. That's how you engage people.
But
And then
whose
get them
fault?
interested.
But whose fault is that, Krishmal?
I
Is it
point the
fo-
finger back at ourselves.
Absolutely. So it's a fault of the civil rights organizations.
I agree with you that we should follow the pattern that is followed, I believe, in the United Kingdom, where first it's put out as a white paper, which is made available to the public to discuss. I think we should
Yeah.
try to bring in a provision like that.
See, now we're discussing about a Mrs. World controversy in the country, but we are not discussing about
The port
the
city.
port city, which is not ours for the next 99 years. And
Are you
this
mad?
is
That's
sad.
much more interesting, no? Some woman comes and takes the crown away and puts on another woman. How interesting is that
Right.
gossip?
Anyway, so
Compared to
gentlemen,
port city.
Faraz, Nadeem, Sonali, I can give you an opportunity to pose a question if you have one. Nadeem.
I don't have a question, but I
But
have...
Faraz, I don't want you to comment either.
No, I'm not going to comment. I'm just going to remind everybody of a little story. And that was about this lady, you know, who was...
Faraz, that's a comment. I can't give an opportunity to make a comment. No,
No, it's not a comment.
No,
It's not a comment.
If
Honestly,
it's a question,
please,
if it's a question,
listen to
I will
me.
give an opportunity.
Okay, it's okay. I'll put it as a question. Do you remember a lady who ended up as the Prime Minister of Sri Lanka, of Ceylon, who came to be so directly from the kitchen, almost. Now, before she went to India to discuss the matter of a small island off our northern coast, she made it a point to get her officials to speak to the former Prime Minister, Dudley Senanayake, before she went to India. And that is the point that I'd like to pose here, or make here, because that has to be a question, right? And that is what the port city is, not some little island off our northern coast.
Again, that's not
right. So gentlemen, that's the question.
Yeah.
Why have you any of you thought about this? What Mrs. Bandaranaike did, and what this government is patently not doing?
Yes, so which is a point that we were trying to make. I hope I may answer on behalf of all. There has to have been consensus, at least in Parliament, as Shamir said, if this white paper had been put through before, allow public debate, even open media discussions, open debates where ministers come and these questions that we are posing now. Ministers come and defend the questions that we will ask. Maybe you all can host a forum, start one, where you'll invite 20 or 30 of us subject to COVID-19 regulations, and we can ask questions from the subject minister who's proposing this. And we can ask, let them answer. Let them answer. So we can ask. I propose it. I propose it. I mean, that's probably the way to go around it.
The time that we have to get a government minister on board. I'm glad that Nishan is here. Representing the Ministry of Justice as a sector specialist for commercial law reforms. Again, Nishan very correctly
I'm not in that capacity.
Absolutely. Again, mentioned very correctly that he is not representing the Ministry of Justice when he is making his comments and remarks. So we can't even direct a question to Nishan based on that. But I'm very happy, Nishan, that you are here today.
Thank you.
And it's always better to get opinions from everyone. Yes,
one quick question to Nishan, because Mr. Pereira mentioned the United Kingdom and the practice of white papers and open debate. But the United Kingdom is also home to what's called the City of London Corporation.
Sorry,
the UK is also, or London is home to the Square Mile, the City of London Corporation, which is immensely powerful when it comes to matters within that 1 square mile of London itself.
It's separate. That's subject to law.
But the thing, when we come to sort of separate bodies like this that exist, even with Dubai, Singapore, the City of London Corporation, which many call the heart of the center of the spider's web of international money laundering networks, coming from the Seychelles, Panama, British Virgin Islands, St. Kitts and so on and so forth. Isn't the fear that this port city, or what the Yahapalne government rebranded as the Colombo financial city, could become something in that vein, separate from the Republic of Sri Lanka, but a hub not just for legitimate business, but also a hub for a higher risk of being part of that international money laundering network?
I would say, answering that question, I have my reservation as well. That is quite possible. That's quite possible.
Nishan, in your
Yes. So in my view, you took us to the City of London, and you talked about independent bodies. Now, I think you are also possessed of the takeovers and mergers panel in the City of London. Now, that is an autonomous body. Power is given by the stakeholders in the city. So it was not codified until 2005. So, but everybody listened to this autonomous body. They were agreeable to adhere to the directions of the autonomous body, being the takeovers and mergers panel. Now, answering your question, now, independent autonomous body is I believe a good thing, subject to them being, I'm talking about the commission. It has to be subject to judicial review and also subject to any suit being instituted against it for any wrongdoings. So that is in respect to the commission, and I believe, and I think it came out maybe directly or indirectly, that it ease, but it will take time to hold them accountable. But coming...
It is on paper, but it's not a practical reality because of the length of time that it takes.
I don't. I think we have, with all due respect to our courts, we have a very novel thinking, progressive judicial system. And the precedence which is here on judicial review at the moment is quite extensive. I don't believe that...
This came up in our program, I think, a couple of weeks ago, that you're talking about our progressive justice system, but within our criminal justice system, if you take it, I think the conviction rate is about 4 to 6%. I mean, that doesn't sound like a progressive and robust criminal justice system.
Yeah, so
my question is this: within an already weak system that has systemic corruption issues, you introduce a body with that much sort of power and autonomy, let's say, and then you say that it's going to be overseen by this system. You look around the world and you have plenty of examples of how such systems have led to increased incidents of crimes like money laundering and terrorist financing. And you can't help but wonder, aren't we headed down that same path with the port city or financial city?
my personal view is we have to wait and see if it goes there. But we have to, if we have our regulatory mechanisms in place and the criminal framework in place, we have our law enforcement which is going to be the same law, and it is not like giving a separate state to any party. This is just, there is a port city, a separate economic zone. That is my understanding of this. So I personally believe, yes, there might be fears or skepticism between, you know, within all of us.
Right, Nadim, we need to wrap up. Nishan, you don't have to answer that.
Okay.
So you can stop there. We're going for a short commercial break. When we come back, it's the final round. Each speaker would get 3 minutes each to sum up on the subject, rule of law, as well as the Colombo Port City Economic Commission bill. Stay connected, stay with Face the Nation. We will be right back. Welcome back. This is Face the Nation. We start off the final round with Attorney at Law Nishan Premtiratna, Sector Specialist for Commercial Law Reforms, Ministry of Justice. As Nishan did make a disclosure before, he is not representing the Ministry of Justice on tonight's show. Yeah, Nishan.
So, firstly, it was a great opportunity to come here and express my views and thoughts of the proposed bill. Investors are not going to be coming here to do charity. I think we need to understand and appreciate that also. We need to give a degree of flexibility and also be able to pitch to investors to a standard which probably goes a little or goes on the same level of footing as Singapore and other models which have succeeded. Now, on a cursory glance of the bill, yes, certain issues were pointed out. In respect of certain issues, I have agreement, but in respect to certain issues, I have my reservations also. I personally believe when you look at the bill as a whole and you look at the entire macro picture of what the bill is proposing and intending to do, it's a progressive, practical, pragmatic step in the proper direction. If we all take a step back and keep our political views aside and look at the bill, or at least the intention of this government by trying to put a bill without just pondering over what to do next after the land is filled there and a golfing range has been already set up and all of that, and then nothing is happening there. This is a good stepping stone. Whether these provisions are constitutional or not are matters which ultimately the Supreme Court will have to decide. Whether there has been my learned friend pointed out, whether priority being given in a judicial framework in our country, whether there is a separate legal system created through this bill, my answer is no. There is no separate legal system. The laws of this country will apply to the, my understanding, my plain reading of the country will apply within the territory of the special economic zone. There is, however, exemptions which are provided in respect of certain laws in terms of Schedule 1 and 2, which are not unreasonable. They are brought in to regulate and expedite, I believe, this is my thinking, expedite matters which are foreseen to transpire within the special economic zone. You don't want matters in the special economic zone to drag for years. So the one-stop concept, yes, the BOI had it. Whether the BOI can expand itself to do all of this is a question. I don't think so. I believe this fresh piece of legislature or this fresh bill is good. And President being given the discretion to keep appointing commission members, notwithstanding, I believe there is a criteria also given to the President, and that there is a mandatory obligation cast on the President to appoint people in respect of those criteria. So on that note, yes, this bill will have to be tinkered with. Let it be tinkered with by all of us, and let the Supreme Court decide if it is ever brought before the Supreme Court and challenged on its validity. Thank you very much.
Attorney at Law Nishan Premtiratna. I now move my attention to Krishmal Varanasuriya, Attorney at Law.
Thank you, Shamir. While Nishan was speaking, I was looking at the lovely picture on the background just behind Nishan. I was thinking how wonderful it is if we can get our country there. I sincerely say this because as a concept I agree that we have to generate commerce and industry. We can't all make government servers every day and keep on paying out of public coffers. We have to generate that income so that our per capita, which is I think roughly about 34,000 now, whereas research shows that a family of 4 actually needs about 56 rupees to live a month, which at least whether that gap can be bridged, we have to get there. But our question lies in, so in that sense, the concept behind enhancing commerce and industry, I am wholeheartedly behind this government. As Nishan said, irrespective of political affiliation, if that's what you want to do and if you want to do it lawfully, I am fully with you. But that's where my question lies. Reading some of these provisions and knowing, as all of us are not as naive as we sometime back were, we are a bit more mature in age now, knowing how things happen in this country, we can see a monster being created, that may place itself above and beyond the law that's applicable to the rest of us in the country. Now that is something we need to work on. This is just a bill still, no. So let's hope that sanity will prevail, whilst yes, we encourage Sri Lanka to get there, where we thrive. All of us will thrive. We want Sri Lanka to get there. That the way we get there is subject to the rule of law under which we are supposed to be governed. Now Nishan mentioned and all of us discussed the extensive powers given to the President, the head of the executive, under this several provisions of this bill. Why we have a question with that, qualified by what I said earlier. Maybe His Excellency thinks I am not going to delegate this to other fellows who ask for 30-40%. I am going to do this myself, so at least I reduce corruption and get something done. Maybe that's His Excellency's thinking. Very good. But now we must visit that in terms of the 20th Amendment that was passed recently. So presidential immunity from suit, all legal suit, except only fundamentalized jurisdictions are open to citizens to question the President's action. Now, whether the extensive provisions and powers given to the President under this bill will be subject to only fundamentalized jurisdiction of the Supreme Court, then nothing else can be challenged by the President. After the 20th Amendment, nothing else can be challenged. Only Article 126 FR jurisdiction. So whether any of this, say if some were to hold, no, these are commercial activities, this is not fundamental rights, this doesn't come to the Supreme Court, then where is it challenged? So these are things that we will have to look at carefully. As I said, don't throw the baby away with the water. If you have a good idea, fine, get opposing views also, and together let's make that new Sri Lanka that we are dreaming of, so that it's subject to the rule of law that the three of us have sworn an oath to uphold.
Thank you very much, Krishmal Varanasuri, Attorney at Law, President's Counsel, Srinath Pereira.
Firstly, I must thank the MTV for having given an opportunity for me to air my views. Secondly, I believe the government is coming out with this bill with a view to, as I stated, expand business activities, attract investors, and I believe all that is being done in good faith. However, we find that there are provisions which are contained in this act which are unacceptable. So all what I say is that I think before this is made law, the government has approximately a 2/3 majority, and as Krishmal said, now there are 8 others who seem to have joined them. So if that be the case, the 2/3 will be there. Notwithstanding the 2/3, I hope Sena Council will prevail and they will look into these shortcomings which are within the proposed bill, and they would make the necessary amendments to ensure that we will not mortgage our system and encourage corruption, resulting in something worse than what was expected. So let's be hopeful. I'm not too sure whether Sena Council will prevail, but let's hope that they will look into these shortcomings and try to see whether amendments could be made in to ensure that there is justice done to everybody. Thank you again, once again, for having given me this opportunity.
President's Counsel, Srinath Pereira. Very quickly before I wrap up, a quick question, if you don't mind, Nishan, because you're sitting at the Ministry of Justice, but I need to ask you this question. Is there any progress on the new constitution that is being discussed at present?
I think the Constitutional Council is headed by probably, arguably, one of the best lawyers in the country, Mr. Ramesh De Silva, President's Council. He's going all around to what I hear, meeting the Mahanayakas, meeting everyone, and he's doing a sterling job. Correct me if I'm wrong, but I'm possessed that they are working, they are gathering views, and they are trying to create a homegrown constitution, taking on everybody's views. So yes, I believe things are happening.
Because I pose this question to you necessarily why, because at least this should be brought in as a white paper where people would be able to express their views and not have it as a decision made by the cabinet and then goes to parliament, and whereas the public, the Supreme Court will only look at the constitutionality of the said constitution in play, and then the people would get an opportunity to vote for it.
With all due respect to Mr. Ramesh De Silva, I think he's doing his take. He has a lot of work. He's going out of his court routine, and he's getting views from all segments of society.
Thank you very much, Nishan. So thank you very much, Krishmal Varanasuri, Attorney at Law, for joining us this evening on the show. Srinath Pereira, President's Counsel, Attorney at Law Nishan Premratna, and also Attorney at Law Sonali Vanigabaduge, as well as onto my immediate left was Nadim Majid, and onto my far left was Faraz Shaukat Ali. Faraz, very quickly, tomorrow 8:30, have you been able to get a minister to answer the phone yet?
Well, the answer is no, but keeping in line with the commitment of the media stables of the Capital Maharaja Group towards the public interest and the public benefit, I assure you that tomorrow Newsline Live will have an interesting guest who will keep to the Newsline ethos, which is asking questions that are decisive, incisive, and upfront and open.
But
so
we discuss. You've not been able to get a minister to answer the phone yet.
We discuss. You decide.
So again,
live on Newsline Live, 8:30 on
something
TV1.
to look forward to tomorrow for us.
Please,
anyway.
please tune in, Shamir.
Right. Thank you very much for joining us, for us. It was always a pleasure. Always a pleasure to have you on board. I leave you tonight with the quote, as I always do. It often requires more courage to dare to do the right than fear to do the wrong. Take care and good night.